The systematic dismantling of affirmative action and right-wing attacks on diversity, equity, and inclusion efforts are showing up everywhere, from courtrooms to classrooms to boardrooms. And the harm to people of color and women and other marginalized groups will be deep, broad, and long-lasting. In the spirit of training our attention on specific instances of this kind of harm, I want to talk about one case today, the Fearless Fund case. The Fearless Fund is a Black woman-owned venture capital firm that aims to help level the playing field for other women of color in business. As such, the Fearless Fund established a grant program to support small businesses owned by Black women. Again, Black women receive less than 1% of venture capital funding, so this was a modest attempt to remedy that gross disparity. And apparently, a conservative group, deceptively named the American Alliance for Equal Rights, took that personally. The group sued the Fearless Fund, claiming that this modest grant program, by focusing on Black women, discriminates against business owners of other races. You may not recognize the name of the organization behind the lawsuit, but its president, Ed Blum, is a very well-known right-wing activist. He is the force behind the anti-affirmative action case that went to the Supreme Court last year. And when the Supreme Court struck down race-conscious admissions programs in colleges and universities, that gave Blum an opening. And now, with the strength of that new precedent at his back, he is taking on the Fearless Fund. And so far, he is succeeding. Earlier this month, a federal appeals court in Atlanta ruled that the Fearless Fund's grant program is likely illegal because it relies on race to determine eligibility. The court ruled that Blum is likely to prevail with his legal action against the grant program, and now the lawsuit can move forward. And the Fearless Fund has been ordered to suspend its grant program while this lawsuit plays out. Again, I want to underscore what the Fearless Fund is trying to do is help remedy a gross inequity in venture capital funding. It is stepping in where racial and gender biases are holding back women of color. And since its founding in 2018, the Fearless Fund has raised over $25 million to invest in Black women-owned startups and businesses that would likely not have otherwise been funded. This is just the latest in a sweeping right-wing effort to undermine diversity initiatives in the United States, and in a post-affirmative action world, there will no doubt be more attacks on the parts of society which we've already managed to eke out some progress on racial equity. Joining me now to discuss the Fearless Fund case is Benjamin Crump, civil rights attorney and founder of Ben Crump Law. He is representing the Fearless Fund in its recent appellate process. So, Mr. Crump, where does the Fearless Fund go from here? There's been a preliminary injunction imposed here stopping the group from hosting its grant program. What's the next step?
We continue on our vigilant effort to give economic opportunities to all Americans, especially those who have traditionally been marginalized, like Black women. The Fearless Fund attempted to try to give a level playing field, to give a seat at the table for Black women and women of color who had always been denied that seat at the table. I mean, their efforts were to help fund the group of people who are the most entrepreneurial, which is Black women and starting small businesses, but the least funded. And then Edward Blum and his conservative enemies of equality come and attack them for trying to do what white men have done throughout history of America. White men fund white men businesses. They don't fund Black women and other women of color businesses. So they were attempting to try to fill a need that was not being met. And for them trying to increase women participation in venture capital, investing in those firms, they raised the venture capital from 0.8008 to 0.97, less than 1%. And for that, the white man said, oh, that's too much. You all are doing too much. These Black women are going to make it where we can't get investments, that we're going to be out of business. You hold 90% of the venture capital space. But yet, because black women get 1%, you sue us. It's a shame before God.
So, Mr. Crump, can I talk about the legal theory of the case? The Alliance brought this case under Section 1981. It's a Reconstruction-era law that was passed for the purpose of allowing newly freed African Americans the same contractual rights that white people had enjoyed. The Alliance is using this against the fund on the view that by limiting their grant program to black women, they've created a contract, and in so doing, impaired the contractual rights of those of other races. What do you say about the deep irony of a law that was enacted to protect black people in the South from having their contractual rights impaired being now used to prevent black women from helping other black women get a toehold in the entrepreneurial space?
It's simply hypocrisy at the most fundamental level. Edward Blum is engaging in the intellectual justification of discrimination. And tragically, the courts, the conservative courts, are ratifying this intellectual justification of discrimination. And what we must really try to educate people on in the court of public opinion as we continue to fight in the court of law is the fact that they are using a law that was designed after the Civil War to make sure that African Americans were free to enter into contractual agreements with white people. Because before that, it was illegal. Black people will go to jail for doing that there. And so here we go 100 years later, and they're using that law now to deny opportunities for black people to do business. I mean, it is just hypocritical on every level. And that's why when they attack diversity, equity, and inclusion, and they attack black literature and black history, it's all part of a greater scheme. And we have to make sure that we are educating our children to deal with these oppressors. Because as I have always said on many occasions, the enemies of equality like Edward Blum won't win this war ultimately, as long as we make sure that our children are more intelligent than those who would seek to oppress them. And in that intelligence, we must know our history, and we must be ready to fight. We must call on President Biden to come and ratify with an executive order the belief in diversity, equity, and inclusion. We call on Merrick Garland, the United States Attorney General, to ratify this belief in diversity, equity, and inclusion by affirming the Civil Rights Act of 1964. Now, more than ever, we have to take a stand behind Arian Simone and Ayanna Parsons in the Fearless Fund and people who dare believe that diversity is a good thing, not something that should be set aside. I never would have believed in 2024 we will be talking about whether diversity was a good thing or not.
Thanks you so much for those insights. We will be watching the Fearless Fund case as it makes its way through the appellate process. That was Ben Crump from the Crump Law Firm.